उसको कॉल पे ले लेते हैं ना, उसको कॉल पे ले लेते हैं. Okay. Hello and very, very good evening. I see quite a few people have already joined in. Hello, Hasika, Tanmay, Preet, Anushri, Moshmi, Srestha. Very good to see a lot of the good people. Anshika, Tanvi, good to see you guys. So today I have a very close senior of mine from law school to speak with you guys, to share a lot of his awesome experiences, not just in terms of Article 370, जो तो topic एक particular तो डालना ही था. He's already appearing in the matter in the Honorable Supreme Court of India. Just by way of a very quick introduction, Pallav is also from National Law University, Raipur, and he's been a practicing advocate in the Supreme Court for more than a decade now. It's about 12 years. In terms of his last employment, he was working with, before starting his own firm, he was working with Justice Nageshwar Rao. I mean, when Nageshwar Rao ji was still a practicing lawyer. Of course, subsequently, Justice Nageshwar Rao was appointed to the Supreme Court as a judge. And after that, Pallav has also moved on to independent practice. He has represented a variety of clients in quite a variety of matters as well, ranging from mining matters to service matters. He's also qualified the advocate on record examination in the Supreme Court. जो Supreme Court का ही होता ही है. It's a very prestigious examination, an honor which is actually shared by the current President of India as well, Shri Ramnath Kovind ji. Pallav has also been a recipient of the very, very prestigious Justice J.S. Verma Scholarship, which is given by the Supreme Court Bar Association itself. And of all the ways that he makes money, I was very shocked when I found out that the Supreme Court Bar Association is actually giving him some 25,000-30,000 rupees per month for qualifying the. Yeah.
It's actually Supreme Court Lawyers Welfare Trust.
It's actually the Supreme Court Lawyers Welfare Association. I see. Welfare Trust. Okay, so I'm sure technical clarity will be a little more at your end. But so this is, of course, the chairman of that committee itself is Justice J.S. Verma, who's a former Chief Justice of India. And the topic for today, of course, is primarily, like I said, on a matter that he's already appearing in. That is in relation to Article 370. जो आप सबको पहले से पता होगा ही, is primarily about the special status for the state of Jammu and Kashmir. But I will open the floor for any of you who have any other questions as well. In fact, यहाँ पर quite a few questions already on the chat box. I see. Weber has a question saying difference between advocate on record and advocate. Can you probably, Pallav, start by answering that, and then we'll move on to Article 370.
Thank you, Debjyoti. See, the difference is that every court has the power to regulate its own procedure, and every constitutional court, and Supreme Court being a constitutional court, has under its powers through its rules determine that not every advocate can practice before itself, and all the findings and all are done.
I think your voice is probably cracking a little. I'm not sure if it's an audio issue at my end, but seems like it.
So, so Supreme Court and its powers has regulated the procedure for filing before the Supreme Court, and they have determined through rules that they will conduct an exam, and once you clear that exam, then only you will be qualified to file and appear before the court. So,
okay,
designation is called advocate on record, where those who qualify this exam become eligible to sign petitions and file petitions to be filed before the Supreme Court.
So there's a few. I'm so sorry. There's a few comments saying voice is actually cracking a little bit.
Just 1 second. Let me just try to change the Wi-Fi.
Is there a way to get that resolved, Pallav? Just for those of you who couldn't hear him properly, basically the Supreme Court, what he was saying is that the Supreme Court has already created a mechanism by which only advocates on records are eligible to file and sign the relevant document if you're actually filing a case. Am I translating that appropriately at least?
Yeah, absolutely, absolutely. That's in some substance. That's it. A special class is created. There's an exam. You clear the exam, and then you are eligible to file petitions before the Supreme Court. That's pretty much what advocates.
Okay, so petitions file करने के लिए आपको AOR का एग्जाम क्लियर करने के बाद जो AORs बनते हैं, सिर्फ वही लोग petitions फाइल कर सकते हैं, और एटलीस्ट कोई एडवोकेट अगर रिप्रेजेंट कर भी रहा है किसी और को, you would actually need the signature at least of an advocate on record for procedural reasons, वरना वो petition basically file ही नहीं हो सकता. And this is something which is there only for Supreme Court, या कई हाई कोर्ट्स ने भी अभी इस सिस्टम फॉलो कर रहे हैं, और हाई कोर्ट
है. आई थिंक पटना में भी उनका अपना एडवोकेट ऑन रिकॉर्ड एग्जाम होता है.
Okay, so if you are qualified already as an AOR in the Supreme Court, do you separately have to give the exam in Patna?
I have to separately give, because like I said, that every court has the power to regulate its own procedure.
Pretty much, I see. So pretty much on the lines of जैसा already I think US वगैरह में होता रहता है कि the New York bar is different and the Massachusetts bar is different, और the Washington DC bar is different. तो वैसे ही हमारे यहाँ खैर बार एसोसिएशन तो अलग था ही, बट आई अज्यूम कि अगर यूएस सुप्रीम कोर्ट में हो चुका है, अरे इंडियन सुप्रीम कोर्ट में हो चुका है, then probably you don't need to give it. But okay, apparently कुछ हाई कोर्ट्स ने भी इस AOR के सिस्टम को अब अडॉप्ट कर लिया है, and you would have to give the exam separately to be able to qualify and appear as an AOR or whatever, sign as an AOR even in the Patna High Court. Okay, so Pallav, coming to the specific kind of topic that we have for today, I'm sure you're having a lot of fun arguing the matter as well, or discussing with the clients. So before we go into the technical aspects of court में क्या चल रहा है, क्या नहीं चल रहा है, and what's the general impression? Are the judges likely to, I'm not saying please predict or let's gamble on the issue, but what does it seem like to you? Which direction is the Supreme Court really inching towards? That are they going to hold all those changes that happened 3 years back up to August 4, 2019 was the date on which all of this happened? So which direction do you think the court is tilting towards? क्या ये जो special status हटा है, कश्मीर को एक यूनियन टेरिटरी बना दिया गया, एंड लद्दाख को एक अलग यूनियन टेरिटरी बना दिया गया. Do you think all of these things are, and what's the specific issue that you are really arguing in the court?
See, since the matter is sub judice, it's not appropriate for me to comment on the possible outcome. That's not appropriate on my part.
Okay, and that's because of the Advocates Act and the ethical guidelines, I assume.
Correct. That's absolutely true. So it will not be fair. So, but what we can do is, considering the audience that we have, we can somehow just summarize the basics and just get an overall understanding on a bird's eye view of the entire issue without going into technicalities. So they're able to absorb the entire controversy and are able to handle in case. I don't know whether there can be questions in the Clat exam on this, but the important endeavor has to be that you get a bird's eye view of the entire issue so that you know what's it about.
Right.
Of course, there's no end to the amount of reading you can do on this issue. There's a lot of history. And, this is such an issue where it's a right mix of politics, history, international law, international politics, constitutional law. And so that's I think is one of the best things to read as a student, and just to open your eyes to the world of possibilities that you have in your matter like this. So to that extent, I feel jealous of the students that they are in that age where they just have so much time in their hands to this.
Pallav, there's a lot of static at your end still, I think. Is that a...
Let me just switch off the fans in case it's...
Probably, I'm not sure.
I'm so sorry, this one's...
Okay, in the meanwhile, I can just take a quick look at... let me take a quick look at the chat box. Okay, okay, Charmanda, you're talking about me, I assume. That's very kind of you. That's very kind of you. That's very kind of you. Okay, so ये तो कुछ अलग ही बात चल रही है. I don't see too many questions on the point yet. Okay, Pallav here is hoping your audio is probably much better now.
Yeah, is it better? Can you hear me now?
We can. Probably you can just if you're using a laptop or your phone, if you can just pull it closer to you.
Okay.
It's also coming from a little bit of distance. I think that's also part of the issue. Should be better now, I assume.
Yeah.
Perfect. Yes.
Okay. Yeah. So as I was saying, it's a very good time to be a student because there's so much to absorb in this matter. And if you are starting from a scratch, if like a whiteboard for which things are yet to be written, this is a perfect time to do it, especially this matter, because this matter stands at the confluence of law and politics, and constitutional law, constitutional politics, international law, international politics. Huge role played by UN and how the time evolved at that time in 1950s and 40s, how the entire issue played out, where the
for the convenience of everybody, just to quickly add a couple of things. Particularly जो लोग I think शायद notes भी लिख रहे हैं, अगर pen paper के साथ बैठे, we have in terms of international law that he's highlighting, we have the instrument of accession, of course, between Raja Hari Singh and the government of India as far as the annexation of or the accession of Kashmir is concerned. और उसके बाद एक UN का resolution भी है from 1948, both of which impose certain conditions on India कि हमें voting करानी है वहाँ पर, as far as right to self-determination is concerned. Both of this, I mean, Raja Hari Singh wale agreement of instrument of accession also had similar conditions. Of course, we have to do that only when certain preconditions are actually satisfied, or conditions precedent at their, as they're called, जब वो satisfy हो जाएंगे, like complete withdrawal of troops, and I don't know if there are some few more conditions as well, जो अभी तक appropriately fulfill तो हुए नहीं है. But how does these legal changes ultimately affect? What are your thoughts? Please go on. मैं तो सिर्फ थोड़ा highlight करना चाहता कि अगर कोई notes ले रहा है तो at least bullet points भी बता दे.
Yes, see, I think the entire controversy revolved on the fact that the other states which were in a similar position, none of them actually negotiated, while Jammu and Kashmir was in a unique situation which could negotiate, and hence those unique terms in the instrument of accession and the Article 370 in total. The entire existence comes out of this political fact that Jammu and Kashmir was in a position to negotiate with us, and hence that special status was given to Jammu Kashmir. And the whole intent at that time is evident from the fact that the entire article starts, the clause 1 starts with the fact it's notwithstanding anything in this constitution. So that is the level of special treatment that Jammu and Kashmir was given at that time. And what is also important is the starting phrase which says temporary provisions. So this is also very indicative of the fact that this provision was included considering the flux that the entire history was in, and considering the fact that, look, for now we are really agreeing with whatever we can for now, but ultimately things have to change. So this is reflective of this. Two things can come out of it. Number one, the reflection of that situation at that time, that yes, situation was difficult, situation was unique, and this was duly considered at the time of constitution. And number two, but it was always meant as a temporary provision. It was never meant as a permanent solution to the problem. So it has to go someday. That was always evident from these things. Yeah.
Right. Sir, please tell us, I'm just looking at the chat box as well. So please tell us about the new delimitation report of Jammu and Kashmir. Well, that's not really directly affected by Article 370 changes or the structural changes that happened in 2019. This is something that continues to happen throughout the country, right? So, for example, कहीं अभी municipal elections होना है, तो उसमें भी delimitation होता है. The Parliament, in fact, one of the agendas of the Central Vista project is to expand the number of members of Parliament itself, which means a lot of delimitation of the constituencies. Again, Parliament के लिए भी आगे जाके करना ही पड़ेगा. So I think we're still waiting to see what all effects might arise as far as because Jammu and Kashmir, even today, I keep on feeling Jammu alag hai, and the Kashmir Valley is definitely different. Even when we look at the kind of political results that we have in terms of electoral outcomes, there also you see Jammu votes in a certain manner and Kashmir votes in a certain manner. Ladakh, of course, now has been made an actual different union territory. So one of the other questions, Pallav, is ये सारे amendments के बाद एक और चीज जो हुई थी as part of the overall scheme of things is Ladakh will not have its own assembly, but just like Puducherry as well as the National Capital Territory of Delhi, Jammu and Kashmir will have its own assembly. However, wo election or finally, it's not really happened. In the meanwhile, all of those, the whole Anuradha Bhasin case about internet ban and all that also kept on happening. So in light of all of these and the constitutional requirement of actually conducting elections, etc., where do you see the Supreme Court actually interfering, or is that part of even the issues that that are currently pending before the court? If you can just enlighten us on that a little bit.
See, I have a unique theory about the entire situation of making Ladakh union territory, and having such a the necessity from the angle of politics to have such a control over Jammu Kashmir. In the and it's just my proposition. I could be wrong, or it may not find favor much out there. But if you read Roman history, then the way Roman Empire was run, the empire always directly controlled the border areas or the border tribes. And that's because Roman Empire was surrounded by aggressors, and the necessity was to protect. So instead of having local people defend their own units, the border areas were always directly in control of the center or the empire or the kingdom. So I think that's pretty much the same logic here, that the reason you are trying to control these border areas is to have center directly control the border areas and protect the border areas, and not let the anybody who affects the territories locally to allow them to control the borders. So I think it flows from somewhere there. It's part of the basics of constitutional politics. And my submission, one submission could be that perhaps the doctrine of separation of powers will come in, and to that extent, the court might say that, look, this is what the legislature, the parliament has to do. So we can't really step into it and beyond the purview of judicial review. So I think that could be one of the major arguments, and that could be one of the stands that can be taken in this matter. So I think
right. Okay. So Pallav is pointing out that ultimately, when there are conflict areas and then there are conflict zones where external territories, and he gave us a background of how the Roman federal government or the federal structure in Rome, it was always the central government basically which controlled at least all the border areas, and the idea of local self-governance because of the simple challenges of national security itself. Center hi hamesha hota hai. It's probably the same logic that is being applied, and at the same time, separation of powers doctrine, which of course, constitution में बहुत सारे provisions directly भी हैं about separation of powers, and also separation of powers has already been held to be part of the basic structure along with independence of judiciary. तो वो सारी चीजों को देखते हुए आगे अगर कुछ कहेगा, it could well be, as Pallav is pointing out, that it could well be कि सुप्रीम कोर्ट यही कह दे कि ये पूरा डिसीजन जो है पॉलिसी मैटर है या जो भी है, और वो सरकार या पार्लियामेंट को अल्टीमेटली डिसाइड करना है, and we will not interfere. It happens every once in a while. You'll see court actually take that position as well. On homosexuality, before the Navtej Singh Johar case happened, the Suresh Kaushal case में Supreme Court actually took a very similar position, saying अगर change चाहिए तो आपको
I think on
Parliament से लेना है. Of course, ultimately Navtej.
Sorry to interrupt. So I think on this thing, क्या कहते हैं?
Homosexuality.
Basically on the one was, I think, repeal on the marital rape issue. Also, right. The government did the same stand.
Absolutely. On the initially before the actual judgment, so we have two. Again, marital rape, of course, is broadly divided into two parts. Should we recognize marital rape in the first place is the current issue that is going on. And एक और जिस पे actually change हो चुका है, जो again as Clat aspirants, I'm sure आप सबको पता है, that whether the woman is married or unmarried, now we have a uniform cutoff age that for statutory rape, which is 18, जो पहले wives के लिए थोड़ा lower हुआ करता था. So that change has already happened. But on the broader question of marital rapes recognition itself, as Pallav sir is also pointing out, उसमें भी similar position लिया है. It could well be यहाँ पर भी कुछ similar type के position लिए जाए.
I also remember reading an article, I think in LQR when I was in law school, that all these things have been seen across judiciaries all across the world.
Right.
And depending on the phases where the world was in. For example, post World War II, a lot of judiciaries gave respect to what the government was doing and said, okay, let the government do that job. It was kind of a trend that was observed all across. And then, of course, the PIL era stepped in, 780s, it all started. And then there was, for the longest time, you let the court do a lot of things which the government should have done. I mean, not to blame the court had no option but to do it because of the way things were. So I think it's more of a, and then you see that, with passage of time, then again, somehow we are in that phase where the government has started taking that stand again, that look, you cannot go beyond certain things and certain boundaries have to be drawn, and, things like that. So it's more about phases and more about trends. And of course, in a lot of areas, the Supreme Court itself withdraws its hands and saying that, look, we cannot touch it. It's for the legislature to do. So I think it's more about the phases and as a matter of policy rather than any technicalities or legalities involved in that.
Okay. Pallav, Daksh has a question. Sir, I'm just going to read it out for you. Sir, please tell us about the scenario before and after the revocation or changes that happened to 370 related to citizenship laws. Now, I don't know if any such changes have happened, and the crucial differences in the constitution of Jammu and Kashmir from that of India apart from a different flag. So first of all, has there been any change to the citizenship law as far as these changes are concerned?
I'm myself not aware. I need to check up on that.
Yeah, I think citizenship law, that's a separate kind of amendment that happened. And there have been 6 amendments to the Citizenship Act to the best of my knowledge. And जो छठा वाला amendment हुआ भी है जिसपे पूरा controversy and all that happened. I don't think that was in relation to Kashmir in particular. Also, is there any difference between the Jammu and Kashmir Constitution and the Indian Constitution apart from a different flag that they have?
See, there are a lot of differences, and I think that's where the provision of 370 comes in, that the whole instrument of accession was incorporated into our constitution by virtue of 370. And that's why the special status and whatever could have been applied to Jammu and Kashmir was only after the consent of the state government.
Right.
And previously before that Constitutional Assembly, and without their consent, then nothing could have been done with the state. And that's where the entire controversy kicked in, that you have, by virtue of this, the series of amendments, you have taken away the special status. The local aspect is the special status because of instrument of accession is to be done away with. So that, in fact, the entire exercise is to do away with those differences. And so it says that the provision of this constitution will apply to Jammu and Kashmir, irrespective of Article 370B, which talks about instrument of accession and the other restrictions which were carved into the article. So that's what the change is. Whatever was happening before, now it's just the Constitution of India. And that is why all the statutes which were there pre-existing, they all had a special name. Like their IPC was not our IPC. I mean, a lot of provisions may have been same, but it's still IPC applicable to that area different from ours. So, and provisions of transfer, I remember there was a recent controversy whether, Section 25 of CPC will apply to transfer of cases, vis-a-vis cases in Jammu Kashmir, all of that. So every time we had a case from Jammu Kashmir, we would look at the local laws of Jammu Kashmir and then, apply them proportionately, which was not the case for other states. In case of other states, only for state laws, we had to look at their special laws. Otherwise, the laws will apply in this field, just, all the rights and obligations would be determined by those laws. So that's what the crux of the entire exercise is.
Right. Okay. So just to kind of quickly summarize what Pallav has just explained, what is fun, and for those of you who just go audio challenge, abhi bhi kuch logo ko lag raha hai. So I'll just kind of quickly just take you through the points. He was pointing out that, of course, the main reason why this whole abrogation of the changes that have been brought in is because पहले parliament का law directly Kashmir में apply ही नहीं कर सकते थे. without the prior permission or the prior consent of the Jammu Kashmir Constituent Assembly and subsequently the Legislative Assembly. So अब वो necessity अब नहीं है, because now Parliament law generally, if you look at most of our laws, section 1 में यही लिखा है होता है, this act shall apply to the whole of the territory of India except the state of Jammu and Kashmir, क्योंकि वहां अप्लाई करने के लिए ही आपको पहले परमिशन लेना पड़ता था. Similarly, most of you must have heard about the property purchase laws and all of that, जो ज़्यादा न्यूज़ में रहा. Also by and large true. He was pointing out that the IPC is different for India, and बहुत सारे provisions same हो सकते हैं, but again, yes, they had the Ranveer penal code, which is Raja Hari Singh's father, basically Ranveer Singh, and so their penal code also continued to be on those lines, or different हो सकता था, और जम्मू कश्मीर का कोई भी मैटर होता था, even in the Supreme Court, तो भी हर बार लोकल लॉज को जाके हमें क्रॉस चेक करके और ये सब अलग से संघर्ष करना पड़ता, which doesn't really apply anymore, because now the Constitution of India is the supreme fountainhead or the supreme legal document that obviously has to be complied with, irrespective of whatever else is mentioned. In 370 clause 2B, did you say वहां पर कुछ exemptions mentioned है, but those don't apply anymore, or whatever, notwithstanding अब apply करना ही है भारत का संविधान, right?
Correct. See, the whole exercise was that whatever cross checks were there in Article 370 to ensure that nothing gets applied on a board-to-board basis, those
right.
checks are done away with now.
Right.
So previously, they would say that, look, number one, the instrument of accession is important. Your powers, union powers, will be limited to what is given in the instrument of accession. And if you want to do something else, then you please have it checked with the government in consultation with the government of state. Then previously it was the Constituent Assembly of the state. Constituent Assembly of the state no longer existed, and before being abolished, they did not do away with the transitional provisions. So that was left hanging. And now what the amendment does is just takes away the entire those checks and balances, and simplicity says all across we'll apply. That was the whole endeavor of that exercise, to bring it at par. We look at other states like this, we look at Jammu Kashmir like this, there's a special status. And now they say, no, you are not here anymore, you are here, we are at the same page now. And all the laws that prevail in India will apply.
Yeah, बाकी states को ऊपर ले गए आप सब बराबर है, one way or the other. We have a couple of, we'll take two more questions, I think, Pallav. One is, the Article 370 is fully removed from the Constitution, or its provisions are changed and Article 370 is present. So off the top of my head, I can tell you 370 is still present, just that the interpretation and application of 370 has been modified, but I'll let Pallav answer if there's more detail or specificity to it.
No, absolutely. Let's, I mean, that notification can be referred to. 1 second. See, what the notification does is that it exercises powers very much under Article 370. So it's not that Article 370 disappears.
Okay.
It utilizes Article powers under 370 and just makes some appropriate modifications, and that's it. So Article 370 very much exists.
Okay, so Article 370 very much exists, Abhishek. And one more question, one last question that we'll take is, sir, were there any different fundamental rights of the people of Jammu and Kashmir and that of the Indian citizens under Article 370? So fundamental rights, I don't think alag the, special rights zarur the, but Part 3 of the Constitution itself provides fundamental rights. So Part 3 of the Constitution, of course, uniformly applies to all citizens, and because a lot of provisions apply even to non-citizens, right? If you look at Article 14 or even 21, the word used is person, not citizen. Right, so anyway, Indian, non-Indian, वो सब पे वैसे भी apply करते ही थे. कुछ जरूर है, like I think Article 19 uses the word citizen. So, but I assume, Pallav, that Article 19 freedoms भी वो कश्मीर के citizens है तो Indian citizens तो थे ही. I assume कि वो same ही होंगे सबके लिए.
See, I think they were pretty much the same, but I need to check whether there were any special restrictions or some kind of a circumventing provision which was existing somewhere else which would restrict the application. But on principle, I agree with you.
Yeah. So otherwise, yeah, Indian citizen, person, those words I think are irrespective of whether somebody is from Kashmir or not from Kashmir. So that's I think the quick overview of. So 370 still exists, guys. There's a lot of background, of course, to it. Like Pallav said, from constitutional politics to international law, ranging from the UN resolutions to the instrument of accession. And of course, even today, you have to understand that जो हमारा separation of powers वगैरह था, उसी को कुछ ना कहीं further ले जाते हुए, we want, because it's a conflict zone and a border area with one of our favorite neighbors, that is Pakistan, and in fact certain portions with China as well. So it's obviously a hotbed, as most of you know. So center needs to probably retain a little bit of control. There's a few differences, etc., that we also kind of tried to look at. Okay, Tanmay, not so confident. Just relax and listen to sir. Sahi hai, Tanmay. So one difference, like free right to profess any trade by any citizens or buy property. Yeah, they were there earlier, and most of these provisions, I think, were derived from Article 35A, which came through a presidential order in 1954. Pallav, correct me if I'm wrong, but
correct. It's not an article which is given after Article 35. If you read Constitution, it actually exists as an appendix.
Right.
It doesn't exist. If you open the Bare Act, you won't find it after.
Yes. Yes, and I think that's something that a lot of law students have suffered with. वो Constitution में खोल के 35A ढूंढने के तो 35A मिल ही नहीं रहा है. But now you know from Pallav sir that it's there in the appendix. It's not there in the direct provisions. But of course now 35A also has been done away with, and वहीं से वो powers आते थे जिसकी वजह से ये सारे restrictions about buying property or the taking away of property succession rights even in certain marital conditions. ये सब कुछ जो होता था वो 35A से मतलब source of that power or differentiation came from 35A. But yeah, that's also done away with. That's absolutely correct, Preet. That has also been done away with. So anyway, thank you so much, Pallav. It was obviously a lot of new information, even for me. I didn't know, so I should have known actually the specific difference between AOR and advocate at least. And I'm feeling guilty about it. And definitely the whole Roman Empire structure and some of these philosophical backgrounds that become relevant when you're arguing in the court are things that as a teacher, sometimes I probably end up missing out on. It was fantastic to catch up with you. Those of you guys who of course faced any kind of audio challenges, you can probably just do a relook at it. And I have also tried my best to kind of bullet point and summarize whatever Pallav sir has been pointing out. Having said all of those things, I hope all of you are also looking forward to a wonderful Saturday evening ahead of you. So please go ahead and enjoy yourselves. Those of you who have other sessions, please go back and attend more lectures. And that's it, I think, from my end.
Yeah, thank you, Devjyoti. Thank you, Clat Possible, for having me. I also learned a lot in this, and congratulations to you and your students. You're a very smart bunch of students. And for those who aren't, Clat Possible will make you smart. So, so thank you for having me. I also learned a lot, and I can't imagine students who are yet to enter law school asking such smart questions. So
yeah, our times were different, Pallav. Students these days know everything and come prepared with all sorts of questions. It's a very healthy atmosphere these days. One of these days we'll have you over for some of our offline lectures, if not in Lucknow, then at least in Delhi. And I mean, whenever you can make time, that I assume it's only going to be on the weekends. But hope to catch you soon. Thank you very much, everyone. Have a lovely evening. Thank you so much, Pallav, for joining us.
Bye-bye. Thank you, everyone. Thank you.